Welcome to this video, which will introduce you to the Voluntary Care in Ireland study at University College Cork. My name is Kenneth Burns, and together with my colleagues Conor O'Mahony and Rebecca Brennan, we would like to introduce you to voluntary care and the key findings of our study. Voluntary care is where a parent or parents make a decision for their child to be cared for by the state. This is for a set period of time, and in Ireland, parents retain some of their parental rights. This is different to court and judge-led decision-making. We will now present the key findings of our research.
The legal framework governing voluntary care agreements in Ireland is provided by a single section of the Child Care Act 1991, Section 4, which provides that TUSLA may take a child into care with parental consent, but may not keep the child in care in the absence of parental consent. If the parent seeks the return of the child, then the child must be returned, or else TUSLA must go to court to seek a care order to keep the child in care. Section 4 does not transfer across full decision-making powers in respect of the child. Important decisions about a child's upbringing remain with the parents. It's simply day-to-day care of the child which passes to TUSLA under Section 4. But Section 4 overall is quite threadbare. It says very little about either parental rights or children's rights. It contains none of the safeguards that we see regarding parental or children's rights in the context of district court childcare proceedings. And it's also far less detailed than comparable provisions from other jurisdictions. It seems to be based on an assumption that because the parents have consented to the voluntary care agreement, that really no further safeguards for rights are necessary. And as Rebecca will now show, one of the things that we examined in detail in the Voluntary Care in Ireland study was the question of whether or not that assumption is well founded.
Voluntary care, by its very nature, relies upon the informed consent of parents to the voluntary care agreement. Sometimes, a parent will approach the Child and Family Agency seeking respite or support through the voluntary care pathway, and in these cases, free and informed consent can be assumed. However, where the Child and Family Agency approaches a parent with the option of placing their child in voluntary care, free and informed consent must be determined. For informed consent to be valid, 3 elements must be present. These are decision-making capacity, voluntarism, and full information. Decision-making capacity means that the parent has the cognitive capacity to understand fully the meaning and consequences of the decision that they are about to make. Voluntarism means that the parent is empowered with the ability to voluntarily consent to the agreement of their own free will, is not making a decision under pressure, and understands that they can revoke this decision at any time, as it is a voluntary decision. Full information means that a parent has full knowledge and comprehension of the menu of options presented to them. This includes full knowledge and comprehension of the terms and conditions of the voluntary care agreement and its consequences, and full knowledge and comprehension of the other options available to them, including the option of going to court and what the range of outcomes of court may be. Like many of us, some parents that come into contact with the Child and Family Agency's Child Protection and Welfare Services may be living with difficulties such as a drug or alcohol dependency, mental health issues, or learning difficulties. While these do not necessarily mean that a parent does not have the capacity to give free and informed consent in general, it is important to determine whether free and informed consent can be obtained from such a parent at the time of signing a voluntary care agreement. It is also important to consider the impact of distress and traumatization on decision-making, particularly at crisis point. Throughout the course of our research, we spoke to many professionals, including solicitors and social workers, who expressed concerns that parents that they had worked with in the past and who had signed voluntary care agreements did not have the capacity to give free and informed consent. This may lead to an unstable placement, where a parent, not understanding what they have agreed to, revokes their consent, and a child is potentially returned to an unsafe situation. Or conversely, a parent may not understand that they have the right to revoke their consent or to contest their case in court. This issue is compounded by the fact that, unlike with care orders, there is no requirement for parents to have legal representation in voluntary care. Although the majority of social workers reported advising parents to seek legal counsel prior to signing the voluntary care agreement, the vast majority of parents in voluntary care do not. Presently, obtaining free and informed consent is at the discretion of social workers, some of whom expressed ambiguity around this responsibility in our study. Our research found that a parent may feel that their only option is to sign a voluntary care agreement to avoid going to court, which, as we know, can be a stressful and stigmatizing experience for all involved. This compromises the voluntarism element of informed consent and therefore makes it invalid in that instance. While a solicitor may not be best positioned to determine whether a parent has decision-making capacity, they can certainly provide the full information required to obtain free and informed consent. Then they can explain to a parent the option of going to court and what that might look like, and also the potential outcomes. Properly obtained and valid informed consent from parents in voluntary care is vital to ensure a better likelihood of a successful outcome for the family and the child, and that is why more robust safeguards are necessary in this area.
In addition to the concerns around parental rights, which Rebecca has set out, there were also concerns around the protection of children's rights in voluntary care agreements in Ireland. One issue is that voluntary care agreements have no maximum duration. They can be potentially open-ended and can go on for years. This is coupled with an absence of independent oversight, so there's nobody from outside of TUSLA reviewing the appropriateness of the placement and the care arrangements put in place for the child and the appropriateness of continuing with the placement in its current form or at all. Related to this is an issue around resourcing. There is a concern that because of the absence of independent pressure being brought to bear by a judge or by a guardian ad litem, the children in voluntary care sometimes receive an inferior level of provision and resourcing for their placements when compared with children who are in care pursuant to a court order. Mentioning the position of the guardian ad litem, a further concern was that even though there's a general obligation to ascertain the views of children in care, the children who are in care through court proceedings where a guardian ad litem has been involved are able to have their views represented and heard more effectively than children in voluntary care, where there's no equivalent provision for a guardian ad litem to bring forward the views of the child and feed that into the process. A final point of concern among our study participants was the potential for instability that can arise from the fact that parents can demand the return of the child from a voluntary care placement at any time. Now, if TUSLA feel that the child is potentially being returned to an unsafe home environment, they can of course apply for a court order to prevent that from happening. But depending on the timing of when the return of the child is sought, it may not be possible to do this in time to prevent the child being returned to an unsafe home environment, and this perhaps is not in the best interests of the child.
An expected finding from our study regarded the use of informal, unapproved care placements with relatives. The colloquial term mostly used by participants in the study for such arrangements was private family arrangements, although in the literature the term uses informal kinship care placements. By private family arrangements, we mean arrangements where children are cared for full-time by family members who are not parents and guardians. The child is not in state care. TUSLA social workers play a facilitative role in setting up the arrangements, but there is no formal care agreement or an order under the Child Care Act. Participants in the study largely talked about the strengths of private family arrangements, but also identified some weaknesses. Of the 7 counties that featured in our study, the use of private family arrangements as a pathway to out-of-home care was commonplace in 6. Our qualitative data indicated that private family arrangements are used sometimes in preference to voluntary care in some cases. In the survey data, some participants noted that private family arrangements exist as a practical solution to a shortage with the supply of formal foster care placements. Furthermore, some kinship carers who would heretofore would have been assessed and approved as formal foster carers no longer meet the increasingly strict approval criteria. However, 5 of the 6 children's advocates who participated in the study and were familiar with private family arrangements, and some of the solicitors, including some of the social workers, raised concerns about a lack of oversight, challenges in accessing resources for these children as there was no formal care arrangement. ineligibility for aftercare supports, and that it was important that the state would use and have a preference for assessed and vetted placements, and therefore these placements do not provide a stable platform for decision making. Those who are caring for children in these arrangements have no legal rights or responsibilities in respect of the child, which makes the arrangements precarious for everyone, especially if there is conflict with birth parents. And not only was there concern raised by some of the professionals involved, there has also been concerns raised by the courts, which have highlighted the vulnerable legal situation of informal kinship carers.
Based on the research conducted in the Voluntary Care in Ireland study, we have made a number of recommendations for law reform and policy reform, which we believe will enhance the protection of the rights of children and parents who are involved in voluntary care agreements. The first of these is that voluntary care agreements should have a maximum time duration, a maximum of 3 months, renewable once only in cases where parents have not received independent legal advice, or 12 months, renewable more than once where parents have received independent legal advice. We recommend that 4 weeks prior to the expiry of a voluntary care agreement, a formal review process should be triggered. This review should be chaired by an independent person, and the review should have the power to make recommendations which are binding on TUSLA. We recommend that children should have access to an advocate to ensure that their views are heard during the course of this review process, or children who are too young to work with an advocate should have access to a guardian ad litem who can present the wishes and best interests of the child during that process. We recommend the voluntary care agreements should have a statutory notice period of 72 hours, which a parent must give to TUSLA prior to withdrawing consent and seeking the return of the child. This is to afford TUSLA a window of opportunity to take any steps which may be necessary to secure the welfare and best interests of the child prior to the expiry of the agreement. We recommend that for older children, aged 12 and over, that their assent should be required to voluntary care agreements in addition to the consent of the parent. And in cases where the assent of the child is not secured, then the case should be more appropriately dealt with through the courts rather than by way of a voluntary care agreement. Finally, we also make some recommendations for policy reform, including an updating and revision of TUSLA's policy around informed consent and voluntary care agreements, and resourcing to ensure that sufficient provision is made for advocates, for children and parents, and indeed for independent legal advice for parents through the Legal Aid Board in the context of voluntary care agreements. And we argue that if these changes are made, it will bring Ireland more into line with international best practice and make better provision for the rights of children and parents in the voluntary care system.